Good evening. I'll try to stay out of the light there so you can actually read it. The presentation tonight is essentially just on if you've got an invention, what you can do to protect your ideas and what you've come up with for any future commercialization. So I'll just let you know who we are, myself and Adele. I'm Andrew Rossi. I'm a patent engineer, which essentially means I'm working towards becoming a patent attorney, but I'm not quite qualified yet. And it also means I've got a background in engineering. So I've worked for many years as a mechanical engineer, acoustic engineer, ventilation engineer, and automation engineer. So I've got a bit of a background for understanding what people bring to us and working on their matters legally. And I'm currently studying intellectual property law so that I can reach that registration. I might get Adele to just let you know who she is.
I'll get a bit closer to Andrew so the mic can pick me up a little bit. My background is in biotechnology, so very different technical background to Andrew. Andrew's probably more on point in terms of the sorts of things that you're all working on. I've been a registered patent and trademark attorney for a number of years. I've worked as a patent examiner, examining patent applications as well, and have that experience in the other side of what we do as patent attorneys. I also have a business background, which is sort of where we come from when we approach intellectual property and protection. If there isn't a business purpose to protecting IP, we generally wonder whether it's worth doing, because obviously there are costs associated with doing it. So that's probably the first place to start when we're thinking about where we start with the patent process. The last little item, of course, as patent attorneys, we have to, I suppose, let you all know that if you do discuss what you're doing, what you're working on, there's no confidentiality during these sessions. So just keep that in mind. If there's anything that's disclosed, it is effectively public by way of discussing it here. So if you can talk about things in sort of general terms, it's probably a better way of getting about asking questions and things. Now I'll just hand back to Andrew to carry on with the presentation.
So the session is going to be broken up into 4 parts. There's a little bit of a primer on what intellectual property rights are, in its most basic form, I guess. The actual problem with the disclosure that Adele just pointed out, a bit on how to develop an IP strategy or what an IP strategy is, and some questions that you might get asked if you were pitching your invention to, say, an investor or trying to get someone involved with it. There'll be a bit of a pause in between each topic, and I might get Adele to come up to answer any questions you might have on the previous section in between. So just getting started on a bit of basics on IP rights. So IP rights essentially get broken down into patents, trademarks, designs, plant breeders' rights, copyright, and circuit layouts. There's also some non-rights, which are they're not registrable rights, so you don't have to file for them through the IP office. Those are trade secrets, so just keeping your ideas secret. Confidential information, so using a non-disclosure agreement or an employment contract, something like that, and just knowing how to do something, and I guess not letting anyone know how to do that. There's also some you don't apply for but are more legally protected, such as copyright, which is just inherent in the works, and unregistered trademarks, which are a little bit more complicated to explain than that, but you don't have to apply for those ones. There are some common law rights. So the most relevant to this group, I assumed, would be patents, protecting how an invention works, designs, which protects how it looks, a distinct aesthetic. Trademarks, which protect a badge of origin, essentially a symbol saying it came from you. And copyright, which is mostly literary works and artistic works, but it also applies to software code itself. So I've put together a bit of an example of, I guess, the top three, being patents, designs, and trademarks. I'll see if I can bring one of these up. So I've used Apple as an example. This is one of their Australian patents, although it's using the international application. It's for how some of their technology works. It's interpreting multi-touch on their phone screens and outputting some sort of interaction with a 3D environment on the screen. They've also got a design which is protecting the look of their iPhone, and this one was actually very useful for them. They ended up suing Samsung and a couple of other companies for infringement of this design, and I think they got quite a bit of money out of that in the end. And they've also got their trademarks. There's hundreds of their trademarks around in different forms, and but this one's been around since 1980, and it's still registered at the moment. And I think Apple has a IP portfolio of over 72,000 patents and designs, so they're prolific in filing. So just a bit of a brief history of IP rights. They can be traced back to at least 15th century Venice, so they've been around for quite a while. And it was basically a trade-off between the Venetian Republic and inventors and creators to say, you disclose what you've come up with and we'll provide a monopoly on that for a period of time, which looks like it was 10 years as far as we can tell. And that was to incentivize inventiveness. So people won't hide what they've come up with, other people can invent off the back of that, and so on. And so when Venetians travelled around the world, moved, they wanted to have those same rights elsewhere, and so patent systems popped up around the world. A patent is really an agreement between the IP holder and the state that the invention is disclosed to the public for the public good, but the state then guarantees that you have a monopoly in that region for a period of time anyway. If an invention is kept secret, then the public might miss out on that public good, that advancement, or if the invention is discovered by a third party, then they may commercialise it ahead of you, you miss out on the benefits of your idea. So it's really that trade-off. So one of the dangers of keeping things a secret was, a good example is the invention of the obstetric forceps. So when this was invented, the midwives that invented it, or one of the groups of midwives, kept it secret by carrying it in a massive box when they were required. They then went in the box, covered everything up, and made a lot of sound effects and tried to make it seem more complicated than it was. Their secret wasn't discovered for nearly a century, and they had an effective monopoly over that. But at the same time, the public missed out on having that invention spread, and a lot of people obviously had poor births. People died as a result of this. So you can see that there is a public good from disclosure of an invention, even if for a period of time it has to be purchased from someone. So the different rights have different terms of protection. They also have different application processes, if there is an application process at all. So copyrights and circuit layouts and trademarks that are unregistered trademarks, it subsists in the work, whereas registered trademarks, it's a moderate process in comparison.
So I don't understand the term. Can you explain that?
Which term?
Subsist.
It's inherent in the work. So as soon as you create a work, it's copyright. You don't have to apply for it.
As soon as you printed it, basically.
Yeah. Yeah, it's something you don't have to register. As soon as you create something, it's yours.
It's recognisable for. It's not just an idea. It's got to be printed.
It has to not be in your head, yeah. You can't, after the fact, say, well, I came up with that. Yeah. In court, that you would need some sort of proof. So, as you can see here, the longest and most expensive process is to get a patent for an invention. Whereas trade secrets, obviously a lot easier in terms of you don't have to apply for anything, but then the burden is on you to keep it a secret. The state will not interfere with that for the most part. So there are quite a few requirements for patentability, actually breaching the bar of being able to get patent protection. The main three are novelty, so newness, inventiveness, and industrial applicability. So novelty is literally a side-by-side comparison of the essential features of your invention compared to what has already come out there in public. So if your invention requires A plus B plus C to be your invention, and someone has come up with A and B, and someone else has come up with C, that's not enough. They have to be together. So the disclosure that this can be is any sort of document. It could be a presentation somewhere. It could be in a room like this if you happen to say something, ended up on the video, or other people heard it. And that's self-disclosure. So second is inventiveness, which is if it's new, it also has to be inventive. It's a bit of a vaguer term, a bit harder to understand than it is just not out there. But going back to that example, if your invention is A plus B plus C, these three features in combination, and someone has come up with A and B together, and someone else has come up with C, it's the bar of, would it be obvious for someone that has seen these two things to go, well, I can put them together. It's either obvious or it's not. And that bar to saying, I've found a way to put these things together, or I've come up with this device which puts them together, that is inventiveness. Industrial applicability is literally just, can it be applied to an industry somewhere? It has to be useful in some way. The requirements for a design are similar, but it's a lower bar to reach. A design is how something looks rather than how it works. So it has to be new, can't have been published before. You can't just take someone else's design and register that. And it also has to be distinctive overall. So when you look at the overall impression of the design, is it in some way unique? And that'll be a side-by-side comparison of your design and everything else that can be found out there. And those two bars have to be cleared in a similar way. That is a much lower hurdle, though, than patents. There's also those non-rights which don't have to be registered. Trade secrets, as I said, it's up to you to keep those secret. But if you have an invention that you keep secret, but then you sell it off to someone and that person can reverse engineer it, then you're not keeping anything a secret. So it has to be something that can be kept secret, something like a process that you do in-house and no one gets to see apart from you. You can keep that more secret than something that goes out to the public. Non-disclosure agreements can help with that. if you do bring someone else on board or tell someone else how to do this process or create this invention or whatever it is. And there could be penalties for leaking that information to the public. If something is leaked under a non-disclosure agreement, there tend to be pretty straightforward penalties in those agreements. And secrecy is also pretty common, like the Coke formula, or I think the KFC herbs and spices, I think are secret in a few safes somewhere. And know-how is usually through an employment contract. So it would say you can't go to a competitor and use our process or use our formulation elsewhere. So are there any questions for mainly Adele after that section? On what they are?
I've got a quick one. What's the unregistered trademark?
So a registered trademark is something you register with the IP office, whereas an unregistered trademark is, there's nothing stopping you using a trademark for your branding, but you don't have the protection of registration. What you can do is, if someone else is passing off their business or their product as yours, then they're essentially defrauding the public by saying this is from them. So you have some rights to say they're defrauding the public, but you don't have the right to say stop using our mark because it's registered. So you don't have as many rights with unregistered, but you do have some under common law for the public good, not for your business's good. So the second part is all about why you need to keep things undisclosed, why that's so important. When you're pitching your idea to investors or a group, whoever, that will, obviously, you have to say what you're doing in some way. But if you are disclosing certain parts, the entire essential features of your invention or your design or your trade secrets, you might invalidate those things through a lack of novelty. So if someone else then publishes any of that information or it's some way publicly found, then you've lost patentability rights, design rights, or your market advantage. So there's a level of disclosure which maybe you can reach, but essentially what it comes down to is, are you providing your entire invention publicly? So if you talk around the problem, so you have this problem and we've got a solution, you're not disclosing your invention. It's not until you say, we solve this problem by doing this, and here's how it works. If you do leave off some of those features, are those features going to be obvious? So maybe you're not destroying your novelty, but someone else could come along and say, well, it's pretty obvious to add this thing in there if you're trying to solve this problem. So now you can't pass that inventiveness hurdle. So designs are similar, where if you show someone your design, you've printed it off and you've made it public, it's not going to be new and distinctive anymore. For trade secrets and know-how, if you're saying you've got a process to do this, are you saying enough that someone else can go, well, I can figure out how to do that, and they've come up with the same sort of thing? So really, that amount of information has to be a bit vague, because it'll really depend on what you're protecting, who your audience is, if there's a non-disclosure agreement in place. But really, if you are having to disclose something, it'll depend on your audience, how much you have to disclose. How much do they need to know? If they're just a casual audience, they probably need a lot less information than someone that's going to be investing in your invention. in some way. And what is your strategy going to be to protect your intellectual property? So on that first point, it's what is your reason for pitching? If you're trying to get some sort of investment, that's the higher level of disclosure. And if you're pitching to someone with industry knowledge, they might be able to take fewer factors and copy, or they may, if they don't have that industry knowledge, it might be a lot more difficult for them to copy what you've got. So as I said, talking kind of around the problem space is probably a good way to start with a public forum. So talking about the technical issue that you're trying to solve and the benefits of what you've got. A black box approach where the problem goes in and benefits come out, but you don't say what's in the box. In private sessions, such as with investors, under the agreement that nothing will be leaked, there might be more details that you'll have to disclose. It's unlikely that an investor is going to put substantial capital into, I have a solution, and you'll find out if you give us some money. Private pitching, confidentiality and non-disclosure agreements are fairly common. But it's not a guarantee that nothing is going to come out of those sessions. There's some risk in there. So protecting your IP beforehand, either filing a provisional patent or a design application or something along those lines before revealing anything, means you have a base point to work from. So if someone was to take your idea and file afterwards or disclose it afterwards, only disclosure from before that filing date is considered. So avoiding specific details, talking around the problem is probably the best until there's some sort of protection in place, even if it's just a provisional type protection. Were there any questions on that area about disclosure? Yep.
Yeah, so if you're talking to somebody and you happen to disclose something, you go and you patent something, because the person you've spoken to was the moral support, or they were someone you didn't assume were really interested. What risk are you actually at with that person coming forward later on, and what time frame afterwards to say that the idea is there with any schools, or what evidence do they actually need to contest it?
So in terms of disclosure to a third party not in any sort of industry, I guess it really depends on the person. It's not good practice, but it's going to happen. You'd have a lot more experience in that sort of that happening.
The short answer is it depends. So, if you have been speaking to someone about something you're working on, and it later turns out that, so you file for protection and they've later contested it, or, the first thing that they have to do in order to pose a risk to you is to contest the novelty of your intellectual property rights. So, assuming they're patent rights, they have to do something about it. But then that raises quite a few questions in terms of, well, what was the nature of the discussion? Was there any implied confidentiality? What was the purpose of the discussion? Was it with a view to license what you were doing, to invest in what you were doing? Would you have presumed that it was under confidential terms? Did you actually say, here you go and commercialise this and it's all yours? So most often these sorts of scenarios come up where there's been some interaction, and often it comes up when there are disputes as to who the genuine inventor or owner is.
It would be more in a collaborative setting?
Yeah, but often you won't just find that someone that you chatted to happened to, decide that for no particular reason that they wanted to make life difficult for you, but it does tend to be. The risk with disclosure is that frequently when you're talking to people about partnership or investment, there are people who have some vested interest in what you're doing. So that can go one of two ways. They may then use that information that you provided them to gain an advantage over you, or they may use it in a collaborative way to work with you. That's the difficulty, that's the challenge. But instruments like non-disclosure agreements, the reason that they're used, a lot of people will say, well, why would you bother executing a non-disclosure agreement before having a conversation? Because they're very difficult to enforce. But at the very least, it shows the intent of the conversation that took place.
Yes.
For us as patent attorneys, in our job prosecuting patent applications, they can be very useful if you're trying to show that a disclosure was unauthorised, because you can recover rights for unauthorised disclosures. So, of course, it's very difficult to do. You have to have the chain of evidence to show where the disclosure came from.
Yeah.
But a non-disclosure agreement is a great starting point. If you don't have that, you
It's
can't
a
do
deterrent,
Yeah.
bringing forth evidence, but you would expect that they would have some sort of evidence, like a recording of the conversation or a third party who heard the conversation taking place or something, if they were going to pay money to take it before.
So,
That's probably helpful for you.
yeah,
If-
that's the thing.
If you're disclosing something in a recording and they present that, they would be presenting that it was your idea.
So the question then becomes, so it's not, in a way, it's not your obligation to protect, it's in your interest to protect your invention, that disclosure.
Yeah.
But that doesn't give someone the right to go and exploit what information they've gotten from you.
Yeah.
So to some degree, that kind of having that would flip the tables, because they would have to show that they collected that information genuinely in good faith.
Right. Yeah, so I guess the point that's been made is that you can't patent something if you've disclosed it. And the point I'm making is, or the question I'm asking is basically, how does someone contest that? You can still go and patent something because you've been talking to somebody. It's up to them to come forward and actually contest that.
Yeah.
And then they need evidence. They need to have created something around the same time or earlier.
Yeah.
And they need to come forward. So you've still got a good chance. You shouldn't, go gospel on that
Yeah.
to stop yourself from patenting something. You've
So-
been talking to a mentor or someone who is there to support you or not to take you for a run.
Yeah. The law doesn't presume that you should never disclose. It's just an artefact of having this novelty and inventiveness requirement. But there are, in recent years, a lot of countries have started instituting these self-disclosure grace periods. So if you self-disclose, within the 12 months before filing a patent application, that disclosure can be excluded from consideration of novelty and inventiveness of your patent application, your patent claims. So there is, in this kind of public good exchange with the patent system, there is a presumption that some discussion does take place. There are humans who are involved in this process of invention, and so there's some accommodation of that. This, when things become litigious, if it does end up in a dispute, there's whether people's actions are in good faith or bad faith becomes really important. So everything is fraught with risk. It's just around those circumstances that either show good faith or bad faith, and then what was someone's intention when they then disclosed something that they had been told. So
Thank you.
that's okay.
So the second point I'll just move back, hopefully. So on disclosure, the second point was, what is your IP strategy? And I think that was to that point, that question a little bit. So if you're it'll determine what is protected, how it's protected, and how the benefits of that protection are maximised. So there is some crossover between certain IP rights. I suppose most obvious would be a patent and a design. In fact, in the US, they're essentially the same thing. They're a design patent. And so if you have a product, you can protect how it works and how it looks. And a lot of the time, there will be crossover between the two. And as I said before, a design is a lot easier to register than a patent. So you can get some rights to protect your product without having to go the whole way for a patent sometimes, depending on what your strategy is for commercializing it. And really, you have to look at why you're protecting your intellectual property. It's a way of mitigating risk for your venture, but it's really only a single possible barrier to competition. So as an example, the industry may not have the technology to compete with you. If you have a process or something that no one else can create, then there's no point protecting it in the short term. So if everyone else is 20 years away, then a 20-year patent isn't going to help you because by the time they catch up, it will have expired. There might be regulations which are required to be bypassed, especially in medicine, medical devices and pharmaceuticals. If you've got something that you've had to pass all these regulatory hurdles to get through, then your closest competitor, even if they figure out what you're doing that day, they're still years away passing those same hurdles to get anywhere. Some industries, the pace of the industry might bypass you quite quickly, so it takes some time to get a patent from the provisional stage to enforced and registered and granted. So if your invention is only useful for the next couple of years before technology bypasses it, then there's no point waiting all that time to go to market with it. If you have a public-facing invention, like a physical product that can be reverse engineered, then that might be easier to for someone else to figure out. So a trade secret isn't going to get the job done, and filing something to give you some protection is probably the way to go. If it's something hidden, like a server-side application which can't easily be accessed, or a process which is locked away, then some sort of trade secret might be the best way to go. And also, if you're not going to make any money out of what you're getting, a patent and a design, trademark, they all cost a substantial amount of money up front. And if you're not going to make anything from it, there's no point in getting that protection. There has to be some sort of benefit from the monopoly. So the last question on that so the cost outweighing the investment, that'll come back to the customer focus. If the customer isn't going to pay for your invention, then the cost of the monopoly is never going to be recouped. Patents need to provide something unique that draw in a customer, otherwise no one will pay for it. A design needs to provide a unique aesthetic that draws in the customer, otherwise there's no market for that. And trademarks should protect branding that customers see as a badge of origin. If it's just a trademark no one sees or knows about, there's no point protecting that. It's important not to fall into the trap of looking for something that can be protected rather than something that should be protected because it's marketable. So figuring out what makes your invention different to what else is out there, and what makes it valuable to a potential customer is going to provide insight into what to protect and how to protect it. That's that question about which IP right to go for, if you should go for any at all, and when to go for it. Protecting the difference between the items ensures that others in the market can't just copy that. If your item, your product, your invention has something really unique about it, but you just protect in the way it functions, and you just protect the way it looks, someone will just change the way it looks and copy the functionality. You need to look at what the big point of difference is that people will pay for. An IP portfolio is less like a series of rights in parallel in a filing cabinet or something, and it's each protecting a core idea or a core strategy, and they're just different layers of protection over the top of them. If an IP right isn't providing some layer of protection to your core business advantage, then it's probably not worth a whole lot. A good IP strategy makes sure that your IP portfolio adds value to your business and prevents wastes of time, money, effort on IP rights that just aren't going to provide any business value for you. It also helps IP attorneys and lawyers in tailoring your IP rights to maximise the value. If we know what is so unique, what your core business advantage is, we can make sure that it works as a layer of protection for that core advantage rather than just something that sits alongside of it and really protects the wrong thing. That IP strategy has to be continually reviewed and maintained to make sure it's always most relevant to your core advantage and it's robust in the forms of protection that you're looking for. Were there any questions on that section? Yep.
Got one question. How do you communicate with your clients? Do you use email?
Yes.
I use Gmail, and Google reads all mine, I'm sure.
I'm sure they do too.
I have a large patent portfolio. How do we get around that?
I mean, you can have a phone call, you can visit, there are ways around it, but, or use a different email service for anything confidential. I haven't read the terms of service for Gmail, but I would assume there's something in there. Well, I wouldn't either, but I would assume there's something in there about them not...
You send me to the dark web. I haven't been there yet.
It's a good point. We don't use Gmail, and that's the very reason we don't use Gmail. We have an obligation to protect information, client information. So we actually use services that are specifically part of the services that are secured. They're not leaked. Our emails are hosted with those kind of guarantees and warranties in place. And if there is any leak, our email providers are responsible for that. So we make sure that we use those services, and you should be as well, or you just keep things in hard copy. I mean, the cloud's fantastic because, if there's a fire in your home, unless you have a fireproof safe and you have plans for something that are going to be destroyed, at least if they're in the cloud, there's a copy of them somewhere. But you do need that security, the data protection security, if you are going to manage things via email. The other thing is, and we do have clients who are very sensitive about information and how it's handled. And often they'll use one service before anything is filed at the provisional stage. Then after the provisional or the complete patent application stage, they can be a bit more flexible about, how they communicate. Because then, there's a certain business cost to not having free communications between staff and third parties, suppliers and things like that. So sometimes we just file a provisional patent because it's time for that particular client to start communicating with suppliers. And they can't really comfortably do that without having some patent protection in place because even Gmail. You don't know where someone else is going to send something. Someone else might be using Gmail and you just wouldn't know. So that's a fair question.
On that point, I work in the publishing industry, and my computer advisors have always said, regard anything that you send in an email as being a published document.
Yeah.
You don't know where it can end
Yeah.
up.
So we have some clients log into, we have a section of our system
Yes.
that's protected and that we can ring fence, so clients can access their own files, and that's often a way around it. So people can actually work in their own files in our secure system, and it never needs to be communicated.
That's
So if you're pitching your invention to any group, some of the questions that you might be asked on these topics, do you have an IP strategy? So ideally you will, but if you don't, then it's probably best to outline why you don't rather than just saying, no, I don't. It could just be that it's too early in the process to do that. You haven't quite figured out what is most valuable. If you don't know that, then there's no point building on top of it. There's nothing there. You don't have your core advantage figured out. You might be in the process of developing that. It might be that talking to potential investors or other groups might help you to figure that out. Do you have any sort of IP protection? Again, ideally you will have something in the works, even if it's just a trade secret or a lack of disclosure, and you can outline to them the lengths that you've gone to make sure that it at least is registrable. If not, you would ideally be able to detail why you have no IP rights and your IP strategy if you do have one. They may ask if you've done any searching yet, and this is something that we do and companies do take very seriously before moving to that IP rights stage. So it's essentially finding out the state of the art and the market, and if you have any barriers to protection. So you're only, one person or a few people, you can't know everything that's out there. So what searching will do is look to see what the state of the market is. It's almost taking the role of the examiner that will be looking at your application and seeing, making sure it's new, making sure it's inventive. So it also helps when you have that information to tailor the IP right a bit more closely to what's out there. If you know what is so distinct about your invention, then you can make sure it's tailored towards that rather than missing the mark. So freedom to operate is essentially the opposite of novelty. So as I mentioned before, novelty is whether or not your invention is known. If your invention requires A, B, C and D, and someone has so A and B, C and D are known together, apart but not together, so you've got novelty. But if someone has already got protection for A, B and C, but not D, then you can't sell the addition of D on top of that. They've got protection for part of your invention. I can't think of an example of that off the top of my head, but add-ons for certain devices, I suppose, is an easy one. Can you think of an example of?
If it's a combination type pattern, I like this.
Trying to think of something in the.
There's lots of old English
Yeah.
case law around the sausage machine. So the sausage machine is a mincer and a stuffer combined, and the combined product, the output of that, is a sausage, something that couldn't be done mechanically before the invention of the sausage machine. So if someone has a patent for that covers a mincer, if you want to commercialise a sausage machine, you still fall within the scope of that person's rights because you're utilising their mincer, even though you might have something that satisfies this requirement for a valid combination which does something that hasn't been done before. You'll still need rights to use a patented mincer and a patented stuffer to commercialise your sausage machine. Yep.
You could still patent your mincer but not under the application making sausages under the assumption that you have to have a mincer to be able to make the sausage.
So the requirement for patentability is different to freedom to operate. Freedom to operate is whether you fall within someone else's patent. So whether you qualify for your own patent, you can actually add features, and if those features are novel and inventive, they materially, and they're not obvious, they materially affect the output of what you do. That's patentable, but you may still need to get rights from someone else. So the original owner of the mincer, you may still have rights and require you to pay a licence or to stop you from trading.
So another example would be like a certain size of iPhone that's now being made and someone wants to make a case for it. The iPhone's being patented on the size and shape, and then someone else wants to make a unique case that fits onto the back of it. Do they?
Under a design right, I think that's what has happened.
So you're saying if someone has
Someone wants to patent a unique
If-
case,
if
but
someone-
it's only relevant to fitting onto the back of an iPhone,
Yep.
so you've got a patent around the shape.
So the article is patented and there's a unique fit for a casing on that. There is a load of patent law around printer machines and printer cartridges. So there have been recent reforms around our design legislation and it kind of intersects with our patent legislation because under patent law, the practice is under patent law, that if you have a patent for a printer, you can't patent the cartridge because it's obvious that the cartridge needs to fit the printer.
Yeah.
So that's kind of the parallel situation to what you're saying. And design rights have recently been reformed to accommodate those sorts of things that don't quite meet the bar for inventiveness, but do justify some right because aesthetically they look different or there's some difference in that respect. But if you have one, you can't have the other. So if that makes sense, if you have one if you've got one thing protected, you have something that fits into it and it has to, that can't be protected separately.
So you couldn't patent the phone case, but you could make it to fit on and then just sell it.
So the phone case might be different because it might have aesthetic benefits, in which case it may be protectable by design because there's a feature that's aesthetic. So there's a portion of it that has to fit. I think the printer cartridge situation is a little bit purer because it has no purpose apart from its function to supply ink to the printer. Whereas a phone case, there is an aesthetic part of it as well as a part that has to function by picketing. That aesthetic part would still be protectable as a design, but there are difficulties. You still have to disclaim the functional part. So that is a requirement under law that you kind of say, okay, well, we're only protecting the aesthetic part. There's not the functional part. And Europeans are very, very strong on that distinction. They're very strict on disclaiming the functional parts of designs, particularly for that situation there, where it may be intersecting with someone else's rights.
Yeah. Thank you.
That's really it for the 4 sections of that presentation. I suppose if there are any other questions about that, that was kind of opened up questions earlier there, but was there any other questions about any of that?
Yeah. Andrew, could you give a sort of a practical example, be it real or hypothetical, doesn't matter, but the type of thing that you would do from day to day? You're some sort of an engineer. I remember from the first frame that, and you've given us a whole heap of background
I'm essentially doing the core work of a patent and trademark attorney, but I'm not registered, so I can't legally do the work for myself. So I'm following Adele around basically, and yeah, she's teaching me how to do the job, and I'm also studying to get that registration. So I suppose every day is different depending on what IP rights our clients have. My area of expertise is engineering, so I'm most comfortable with patent rights. So depending on what stage we're up to, that could be talking to the client to find out what their invention is, what stage they're up to, and what their IP strategy is. If they're up to filing some sort of patent rights, it could be drafting the provisional patent, trying to explain in as much detail as possible what the invention is, to a point where if going back to that provisional at a later date, they'll be able to understand what the invention is. So it might not be complete at that point. They may not have finished development, but they'll know what the inventive aspect is. It will have reached some sort of point where it can be described in detail. It could be putting drawings together for the invention, the patent document later. It could be drafting the claims which cover the scope of the protection. So you've got a description of the invention, and then you say, but here's what we want to protect, this bit here. That usually takes the longest overall.
I think what does Adele do? I think the short answer for Andrew, for the question about Andrew, is Andrew spends, and patent attorneys in general spend a whole lot of time prosecuting patents. So prosecution is this process whereby we'll negotiate patent offices around the globe typically. I don't think we have a single standalone Australian patent on our files. We have patents that are typically protected in at least typically 3 to 5 countries.
Yeah.
So what we spend an awful lot of time doing is putting submissions to patent offices to support our position that our patent claims are valid and they should be allowed by the patent office. So we spend an awful lot of time.
You're preparing everything
Yeah.
submitted to the body that will approve.
And usually they find rejections, they find prior art, which is documents that they think are the same as what we've patented, and we'll have to explain to them why things are different, why what we've done is very different to what the patent office thinks is too similar. But the approach that they take is usually that the onus is on the applicant, so on us, on behalf of our clients, to justify why this invention is meritorious of exclusivity that's provided by a patent. So that's, at the moment Andrew's working on probably mostly European and US arguments. So typically we're not only working on patents that are going to be granted here or that we're advocating for here in Australia, but usually in other countries as well. So there's a little bit of having to manage different process and different nuances in the law. The Americans do things very differently, and the Europeans can be real sticklers. And I think we're somewhere in the middle in Australia. So when Andrew's drafting patent specifications, he's going to consider all of that ahead of time. So this IP strategy, this activity of developing a strategy to obtain IP rights. Apart from actually selecting the right, it goes well into, when we go global, when we take this into these different patent offices, how are we going to formulate arguments? Because we have to plant the seeds of those in the document when we file. And that's what we spend a lot of. So we spend a lot of time around the claims, which are the actual statement of the monopoly right, and an awful lot around how are we going to position this description, this problem solution that we're presenting to the public domain, so that when we are questioned about why it's meritorious, we can actually say, well, this problem that has not been addressed until now is very significant. You know, there are lots of people who are suffering, you know, who face this problem. It's commercially significant. There are people dying some of the time. We do a lot of medical device work. You know, there are people who suffer and, you know, have medical issues as a consequence of issues that, you know, problems that aren't addressed at the moment. So all of these sorts of arguments, we sort of try and build that plan at the very, very start.
Thank you.
It's okay. And I think, what is it, just a few, you know, disputes will always come about from time to time. Andrew said a client in the US, a music company that had just had a win. They had a squatter try to take their Australian mark. So yeah, we just recently had a good result there, defending their mark. This is a 100-plus-year-old music brand. So yeah.
Yep.
How do we go about beginning our own searches to see what patents are already out there?
Do you have a slide with
Uh,
any domains?
I don't think so.
That will be one to prepare for next time.
Hmm.
Next time. So there are lots of resources. It's a really, really good thing to do because of this inherent, you know, quid pro quo of the patent system. Everything is in the public domain. Everything is accessible. And the idea is that you do get the benefit of all that knowledge. Google Patents is actually great because it's very, very usable. They started with just US patents, but now they also have European. Most countries are actually part of their database. So it's a really good resource. The great thing about starting with Google Patents is they have images, so you can search and actually see the figures of the patents that you're retrieving from Google Patents as you're doing the searching. So that's really useful to actually understand what's already been done, what other people are doing.
Will they also show when patents expire?
Yeah.
Yep.
Yeah.
Usually, yeah. There are different levels of information on there. It's not perfect. Every office is different, sadly. There's no kind of unified database. It's getting better. There's a group of, I think it's called the 5 offices or something, and they exchange information. So they've even got a website now where you can look up an application that you've filed and see all the information from 5 different countries and what each of the examiners has cited, a timeline of when these documents came out, and there's a lot of information. They haven't quite provided a lot of that to the public very well just yet. It's very hard to find and very hard to actually get the information, but they are sharing information much better between each other. So the databases are getting better. Google Patents is mostly getting it directly from the USPTO. There's also eSpaceNet, which is the European Patent Office, their sort of database.
What's the name of that one?
eSpaceNet. It's literally just e-space net, as in the word space, I mean.
It's another, when you're searching, it's great to use eSpaceNet and Google Patents because eSpaceNet does more of a Boolean search.
Yep.
So you get very different results. Sometimes with Google Patents, you don't know what algorithm, what machine learning technique they're using to retrieve what you're searching for. So it's good to use a few different databases and you get different results come up because different machine learning techniques are used between them.
I'm just curious about, you say that you have businesses here in Australia and the US and Europe deal with inventions and people and clients coming from those parts of the world. What about places like China? How do you work with China, if at all? I don't know, I'm asking. Considering the fact that they have
So,
Copyright, infringement, all these things that.
one of the most important things about if you're entering the market in China with a product that's branded, China is one of the only or one of the very few countries in the world that doesn't have these trademark, unregistered trademark rights at common law. The reason that's a problem is what it means is if you adopt a brand in China, and someone else you're using it, and someone else decides to register it because they like the look of your brand, you have no common law rights to say, no, we were the first to use it. So that second entrant who gets the benefit of your branding and the exposure of your brand in the Chinese marketplace, they have exclusive rights over you. They can make you stop using that brand.
A big example of that was Penfolds. They had an issue where they wanted to enter the Chinese market and someone already owned their trademark there. And I don't think they got it back in the end. They may have started trading under a different name in China, or they may have it back now and they're trading under both. It got very messy and very costly for them.
So that's why these common law rights are really important, because for a lot of small traders who may not register their brands straight away, they may not register their marks, they always have these rights that they can use to recover marks, or at least keep on using them without being sued, as long as as long as you were the first to start using that mark, or you were using it concurrently, unknowingly with someone else, you can quite legally remain the user of that mark, which is very different. This is the first, major difference with trading in China. Trademarks are very different.
It's really the law that's different.
Patent law has actually come a long way in China.
It's very similar to the US these days. I think they're mostly basing it on US law.
Enforcement's a little bit more difficult. The courts always take a little bit longer to catch up with how law changes. But I think that's improving in China. And in terms of the practice that we do in obtaining rights, we work with you have to work with a local attorney in any country that you're obtaining rights in. But we work with some excellent Chinese attorneys that do very good work. So as long as you're working with good people, you do get good results. And we've had some very good results. Very quick turnaround, surprisingly quick in the past few years. So they've done a really good job of getting on top of their backlog of processing applications quickly.
Last question from me, sorry for holding on, but just, is there a situation where you wouldn't advise somebody to go down the right route of patent protection based on them being in a niche industry, or having an idea but not having the know-how, or not understanding technology, needing to collaborate, or not having the funds, or being in the market? Is there, when people are asking you about, how do I patent and what should I do? Is there examples, or is there some advice we can give around when it's not advisable to patent but still go on?
Firstly, you're not going to recover the costs. So you're building a business, you do the financial projections, and you have you have some positioning, you understand where you fit in the marketplace, what your competitive position is. Firstly, if your financial projections don't have to be cost recovery on patents, it makes no sense together to obtain. So that's first easy, strike out for that. Andrew touched on a few good ones. If your product is facing rapid obsolescence because it's in a fast-paced industry, it may not make sense. You may not be able to get rights that are broad enough to have that longevity as the product evolves. So there are a lot of tech.
A lot of, I would say the kind of blockchain type inventions, which you hear about people with these big ideas and then not even a year later they're completely gone. And I mean, the time frame for getting patentable protection on that is longer than they're even in existence. So there's just no point going down that road for some of them. Some of them have stuck around longer, but those types of things where the industry moves very quickly, it's maybe not in their best interests.
You may be better off putting your money into marketing or into other areas. You might, that real question around, I mean, everyone has finite resources, even from the point of view of you don't want to put any more capital into something. So you then have to question your best spend. Do you get more back from investing in a patent than you get from, you know, either getting foreign customers elsewhere?
Yeah, it's quite difficult as a startup having the knowledge to put multiple elements together to have a patent. And so is that something, would you recommend if it's not worth going ahead with an idea if you couldn't patent it? Or do you?
No, absolutely not. So I think having a good IP strategy is better than having a patent. So you're going to get more investment, makes more sense. It's going to be on the mark. You're going to get more value like out of it than just getting a patent for the sake of getting a patent. We were just talking earlier, so what we've seen is quite a good strategy. What we've seen with a few clients is we've developed a strategy where you've got a new offer into the marketplace, not totally certain how it's going to go, and you can't really test the market without actually putting like a beta version out there and seeing how it goes. So why prototype? Why not just go for a simple version of the product and just release it and see what people think and get feedback? So we've developed strategies where we've gone, okay, well, we'll develop this particular product to basically onboard people.
Test the market.
Yeah, test the market, see, iron things out, onboard people who typically would, you know, seek out this sort of thing. And then where the real advantage is, where you think the real advantage is the feature that really attracts customers and keeps them with you, then that iteration is what you protect.
Yeah.
So then what we have to be careful about is we kind of say, okay, well, what features do we have to exclude, or how do we avoid disclosing certain features from that, you know, the initial product, so that we don't validate later rights. And we've done that a couple of times, and that's a really good strategy because it kind of de-risks things.
Get some cash flow going.
Get some cash flow going. If you're going to prototype anyway, you know, 90% of the way there sometimes.
Yeah.
So,
Thank you.
that's all right.
I think one of the things for me that I've learned since I've been involved with the Inventors Association is that you may have a really good idea, but it's something that may not be an idea that it will be profitable or it will be something that the market wants. But nevertheless, it might be a brilliant idea and you feel really good about this idea, but what do you do with this idea if you can't really implement it and sell it? You know, that's.
So we've had a few clients who have had, they've been medical related. They're not the sorts of things that you want to cost recover if you're developing a product, but you don't necessarily, in these couple of scenarios, there's more to gain by sharing than there is by making a margin on the product. So we've actually used IP and designs patents as a way of licensing broadly. So once you have the IP rights, you can make them open. If you don't have IP rights, it's a strange concept, but if you don't have the right, you can't make it open. It isn't, you know, IP rights aren't just open because you haven't protected them. So we've actually adopted these sorts of strategies where we said, okay, a little bit like Creative Commons licensing that government uses and a lot of organisations use. If you want to commercialise this or you want to use this, then you have to give back, and that builds the critical mass of good that anyone else can use as well. So we've done this with, you know, very niche medical devices that are very specific in terms of design. You know, they need to have there's a massive body of research behind them. They have to be designed a particular way. So that's how they've done it. That's how they've developed a business strategy. Other people can use them, but they also have become collaborators. They also contribute back. So there's lots of ways. Really, a good business strategy. People who do what we do
think that might be the last question. So thank you for sitting through that. Some of that information can be a little bit dense or abstract sometimes unless you have something to apply it to, but it can be useful to kind of get your bearings if you have an idea and don't know what to do with it. So thank you for that.